Hi everyone, this is immigration lawyer John Khosravi. Thank you for joining us this May 26, 5 p.m. Pacific time for our regular Q&A session, taking your questions about U.S. immigration and all the insanity that goes with that, and confusion and unknowns. Happy to be here to help. So we're going to talk about general educational kind of stuff on YouTube, LinkedIn, Facebook, and TikTok. Just post your questions here and my associate will help me answer these and pick the questions. We also have a free raffle for those watching live. So if you are watching this live, every 10 minutes or so, we're going to pick one person, so 30-minute show, 3 people, get chosen. You just got to watch, and then when we announce that you won, we'll give you information on what to do. What you need to do is like, subscribe, and write in the comments, free consultation, whatever it is in the live show, and we'll pick one person every 10 minutes, and then you need to take a screenshot to prove the account that that was chosen is yours, and from there we can send the information. So with that, let's get it started. How much money or income does my wife need to sponsor me? So the sponsorship, financial sponsorship for a family-based case depends on the family size that you have first and foremost. So let's say your wife's in the United States and you're married and you don't have any kids or any other dependents. So a family of 2, you need to look up Form I-864. Form I-864 annually changes and it lists, depending on your family size, how much money you need to earn to satisfy the affidavit of support requirement. So if you go to the website for the I-864 on USCIS.gov and look up a family size of 2, right now you need to make $21,775. Now, if your wife's in the military, it's a lower, but generally most people for a family size of 2 need $21,775. Obviously, I don't know your family size, if you have kids or if your wife has sponsored someone else before as well. That could be considered a family member for the purposes of the affidavit of support sponsorship. So there's a lot more information I need to know, but generally speaking, for a family of 2 that everything else is clean, I just round it up. Instead of saying $21,775, I just say $22,000 a year. You need to prove it by pay stubs and income statements, employer letters, taxes, all this kind of stuff, but that's what you do there. Tim Orbeck asks, what if during the adjustment of status interview, I-693 was not asked by the interviewing officer? The I-693 is a medical checkup and they didn't ask for it, so that it's on the record. And it was not filed initially. Is it going to affect the decision? So if you had an interview and there's no medical checkup for I-693 there and you didn't give it, they usually, almost always, will issue an RFE saying, please give it to us. Now sometimes the officers may completely forget and your case move forward. If you know that they didn't get it, you should on your own contact them and give it to them so it's on the record. You don't want to let that be hanging. Rarely some officers will deny the case for not having sufficient documents. It's a jerk move to do because they could just ask you for it. But if you know it's missing, you should contact them and give it to them before a decision is made, so it's in the record. Even if they mistakenly do approve it without it, you don't want the record to be missing, something like that. So I would say, talk with a lawyer, but you may have to just give it to them and get that in. Are visa holders from the EU, from Italy in particular, allowed to return to the US after a brief trip abroad? I was vaccinated here in the United States. So generally, if you're visiting the EU, you cannot return to the United States unless you're in a non-EU country for 2 weeks. So you're subject to a bar unless one of the exemptions apply to you. For example, if you're married to a U.S. citizen, you have a minor U.S. citizen child. There's various exemptions that are there. If you don't have it, you have to get either a NIE, a special exception from the embassy, or you just wait in another country that's not subject to travel ban for 2 weeks. Then you re-enter. And in these kind of cases, if you're a visa holder, we don't want you to leave. So I have clients that need to go back to UK, United Kingdom, they need to go back to Italy. I say, sorry, you shouldn't do that, because if you go, it's not clear when and if you can come back. So unless you really have to, be prepared for a lot of headache, unless one of the exceptions and exemptions applies to you specifically. All right, Ambrose asks, hello John, as you may or may not know, I have been approved I-130 from 1995. I got approved the same year. My priority date is current. I have no previous criminal or American immigration violations. Will I be able to visit my U.S. citizen petitioner's sister in November and adjust my status immediately? So, you can't enter the U.S. with a tourist visa to adjust status in the United States. So when you get a tourist visa, you're saying, I'm coming to the U.S. temporarily and I'm going to go back home. But if you come in and then file for adjustment of status, it could look like you lied. You didn't really want a tourist visa, temporary visit. You're coming here to be permanently here. So it's not recommended that you try to pull something like that. It could be troublesome. I need to see the whole case as you keep the I-130 alive at the embassy. There's a lot of different things that we need to check, but with regard to you coming as a visitor, unless you have an H-1B visa or an L-1 visa or something like that, I don't recommend using a tourist visa to come to the United States with the intent to adjust status. So, I mean, if you come here and then your intent changes while you're here, then that's one thing, but you told me that's your plan, so that's all I can assume. Abdullah asks, hi, if my marriage hits the rocks before I apply for the waiver on the first 2 years green card, what do I do? Will I lose my residency status because my marriage has hit the rock? Well, you know, you can still keep your green card if you have a 2-year green card. So for those who don't know, if your marriage is new when you get the green card is really valid for 2 years. 2 years after getting the green card, you have to file a form I-751 removal of conditions to prove that the relationship was real. And so if you're not together anymore, you can still keep the green card, but it becomes a hell of a lot harder. You have to prove that the relationship is real still with documentation of your relationship, joint accounts, all this kind of stuff. And at the same time, file for the waiver, say it was real, either it just didn't work out or there was abuse or some other kind of things, waiver things that you could request. For that, one thing to important note is they cannot approve a case for the most part, unless some sort of exceptions, but for the most part, they can't approve the case if you're not divorced. So you should definitely talk with an immigration attorney. I can't recommend you just go and get divorced, but depending on where you're on the timeline and stuff, seriously thinking about getting divorced sooner rather than later is an important consideration to have in these kind of situations. We got to really analyze the case and see the documents, the timelines, all this kind of stuff to give individual advice on that. I'm sorry to hear about your relationship, but that does happen. Alsan says, hi, can I expedite my I-130 petition to overseas? I'm not sure what you mean petition to overseas. What you probably mean is you got married or you just have an I-130 petition pending and you want to get it done sooner so you can go to the National Visa Center. You can give it a shot. I'm not optimistic. They're really hard on this kind of stuff. I have a client who has cancer, who just was diagnosed with cancer, and we requested an expedite and they just denied it. And I was really shocking that they did that. So I'm not optimistic, but you got to do what you got to do. Give it a shot. You might get a better officer than the one that we dealt with, but that's the situation there. Thank you for your question, Alsan. Next question from Armand says, what happened when you get a felony and you have only a green card? Asking for my cousin. Sorry to hear that. I mean, there's a good chance that you're going to be put, or your cousin's going to be put into removal proceedings and be kicked out of the United States. Now, it depends on what the felony is, what the charges are, all this kind of stuff. But it's possible that they could deport him. So that's, I mean, your cousin immediately needs to have a criminal attorney if they haven't had one already, but also an immigration attorney that's really well versed and criminal immigration law that can help with that to see what exactly it is. There's some exceptions, but generally, if you have a felony that's pretty serious, there's a good chance that they could remove you from the United States based on that, unless some sort of things pop up. Can you travel outside the USA if you have a record of misdemeanor or suspended sentence over 20 years? There's risk. I need to see the actual record itself, so I can't advise on that, and it's not a specialty of mine, criminal immigration, so I wouldn't set up a consultation with me on that. But there's risks involved. First of all, I got to see what the misdemeanor is. Some misdemeanors are deportable offenses, so it really depends on the facts and details and how the law is written in your case. Even if it's not a problem, when you do re-enter the United States, there's a good chance they're going to take you to a secondary room and spend a lot of time asking you questions. So we prepare for headaches on that, but we really need to review the case in detail. Michael asks, people pronounce my name incorrectly every time, so you think I'd change my name of citizenship? Yeah, you can change your name of citizenship. Not every field office, not every office does name changes. So like for example, San Francisco typically does do name changes, Los Angeles does. So if your local office where you do citizenship naturalization does, you can change your name. If not, you have to go to court, your local county court, and just update your name there. Deborah asks, what happens if an I-290F approval time runs out while waiting for the interview date? Is there a COVID extension? So the I-129F is the fiance visa form that you fill out, and once it's approved, they only give there's an approval timeline of how many days. It's like 4 months or something like that. If it runs out and the green card is still not issued, immigrant visa that is not issued by the embassy, it's still okay. The embassy has full right to automatically extend that. So I don't know why they put a time limitation on the K1 I-129F approval notice, but if the time runs out, the embassy could easily, they have full discretion to increase time. It's not something I worry about for my cases, so I don't want you to worry about that either. All right, everybody. Thank you so much. Thanks for joining. We'll catch you on next week, 5 p.m. Pacific time. We're here live on these various channels, YouTube, Facebook, JQK Law is the name. Search that, you'll find it. I'm immigration lawyer John Khosravi. Everyone, thank you. God bless. Be safe. I'll see you all soon. Bye-bye. I hope you enjoyed this educational video. We have a second channel with much more information as well at JQK Immigration Clips. Please check that out. Also, you'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.